Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything to do with personal injuries in the law today. My name's Tony Carbone. I've been practicing law for just under 30 years. With me tonight I've got Don Maffia, partner in a law firm in transport accidents. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And an up-and-coming lawyer in a law firm dealing with transport accidents, Aki Munir. Good evening, Aki.
Hello, Tony. Hi, viewers.
Tonight, viewers, we're going to be talking about an episode where work cover and transport accidents overlap and interact with each other.
But first, Tony, why don't we talk about what's in the news?
Viewers, there's been a lot of stories in the news. There's been a lot of interesting stories and not so interesting, but the one I want to talk about first on is this one in America. Bobby Russell, a US veteran, files a lawsuit claiming HIV misdiagnosis. What are the facts, Don?
Yeah, this is in America again. So this man went to a clinic and was diagnosed, or misdiagnosed allegedly, with HIV and started being treated with HIV medication, the whole lot. And he also decided to have sex with people with HIV positive people.
So, Aki, what we've got is a bloke who they've told has got HIV where he doesn't. Then he goes out there and irresponsibly or irresponsibly, whichever way you want to look at it, starts having sex with people with HIV. What do you think about this?
It's a scary thought, Tony. You go to the doctors thinking that they'll get that diagnosis right, and you know it's of such importance. And to get it wrong, it must have been shattering for this person involved.
Well, I guess he was acting responsibly, wasn't he, Aki? Because he's going out there having sex with HIV positive people thinking he's positive.
But Tony, the problem now is, of course, now it's come out that it looks like he never had HIV, but now he may have HIV and he has to do all the tests again.
What's a case like this worth?
In America, it's worth anything. In America, I think there's no limit. But Tony, it just goes to show, why wouldn't you have got a second opinion?
Oh, but that's not the test when it comes to suing a doctor, is it?
It's not, but at the end of the day, if it was me, I would get a second, third opinion. And if he got that further opinion, the results that were there would have shown that he didn't have HIV.
Viewers, he's gone to what I presume is a reputable clinic. They've told him he's HIV positive in circumstances where he's not. I would have thought whether he's gone for a second or third opinion, he's got a very good case in negligence against the clinic, and I'd imagine his damages are unlimited because it's a probably loss of life.
Well, it is.
In the not so distant future.
Like we said at the moment, he doesn't know if he has it, but it sounds like a probably good chance he has.
Yeah.
Now, and definitely, Tony, I mean, that's right. I mean, I say get a second opinion, but at the end of the day, the negligence was done at the start when he was misdiagnosed. So.
Viewers, we'll come back to this case in due course when things unfold. What about this poor taxi driver? He's on the freeway, he's got a blown tyre, he gets out of a car to change his tyre, bang, he gets cleaned up. Aki, it's insane. I mean, a lot of bad drivers in this place, isn't there?
It is crazy. You just don't know what will happen on the roads, and you pull over, try to do the right thing, try to change your tyre, which is what you have to do. And you wouldn't think that someone would come along and not take notice and not look out and be aware of what's going on the roads.
Don, this comes back to what I've said on many occasions in the past. It sounds to me that when we're driving, there's a lot of nonsense going on with phones, playing with DVDs, lighting up cigarettes, putting your makeup on, all sorts of nonsense.
Driver distraction, Tony, and it's all too common on the freeways. You hear in my practice as well. Hear quite often people on the side of the road for emergency reasons are parked there, and then another car comes and hits them. Whether they're there, people trying to skip traffic, they go into emergency lane and don't see what's going up front, or people who are distracted, don't see the car in front, stop, so they swerve and they're going to emergency lane. I mean, there's lots of reasons, and a lot of it is because of driver distraction.
There's a simple message out there, viewers. When you're on the road, forget everything else. Don't be just concerned about yourself. Worry about everyone else around you, because bottom line, your actions are going to have consequences that are going to be far-reaching into the future. Not only affecting the person you've run over, but also their families and other loved ones. There's this massive gap these days, Dom, between physio bills and what Transport Accident Commission is prepared to pay to physios. Why is that happening?
Well, it's like, I explain it like the Medicare gap. So if you go to a doctor, most doctors who don't bulk bill, they'll charge you an X amount, and you go to Medicare and you get hopefully 3/4 of it back. It's a similar scenario with TAC, particularly with physiotherapy payments. So people who are receiving TAC compensation, they go to a physio, and the physio charges a lot more than what TAC reimburse, so there is a gap. The result of that, Tony, is that a lot of people are not getting physiotherapy treatment because they'll go to a clinic, the clinic says we don't do TAC work, or we don't fund it through TAC, you're out of pocket. because they're already out of work and they're restricted in their wages, it becomes all too difficult for them.
Well, they don't get the treatment, do they, Aki?
Well, that's correct. A lot of physiotherapists are not taking on TAC clients because they're worried about that gap and not getting their money back. So, I mean...
But also the injured party's not going to go to the physio thinking, I've got to find $50. I mean, $50 to someone that's not working is a lot of money.
That's exactly right, Tony.
Well, Tony, it says here in the article that the average cost has rise for physiotherapy consultations, so just consultation, $64, and TAC will only pay back $49.52. So there is a $14 gap there. And that is only for, I'm guessing, standard consultation. If it was a prolonged consultation or longer consultation, it would be a lot more. So, look, it's increasing and it's a problem, I believe.
They should do what they do in South Australia. The government's actually set out schedules of payments for treaters, and if you charge more than that, you get fined.
Yep.
So there's a schedule, it's in cahoots, everyone's in cahoots, it works well. We should implement that in Victoria.
Well, look, with the TAC, working closely with the TAC, they do adopt the Medicare benefit schedule.
Yep,
It's just that these doctors, physiotherapy, just go over and above beyond that. And it's quite a common practice across the board. So,
Aki, there's a drunk man in a car, he's blown .26 whatever, and it's a bizarre case because on a technicality, he gets off. This is insane. What's happened there?
Oh, it's crazy to think that someone that's blown 5 times over the legal limit would get off without anything. I mean, originally the sanction was handed down. He was fined $500 and he lost his licence for 2 years. And it was overruled on the basis that of a legal technicality, which is just crazy.
And Don, what was that technicality?
that he actually wasn't in charge of the vehicle. He was too drunk to be in charge of the vehicle. Even though the vehicle was running and he was behind the steering wheel, he was just too drunk to be in charge.
Surely that's going to fly in the face of what's considered reasonable and decent behaviour in this state, or any state for that matter.
Yeah, I guess it's a loophole in the law, Tony. It's how you interpret it. Yeah.
Dirty doc, treated a patient. He's been banned. I'll throw it to you, Aki, because it's disgusting, this. What happened?
It is disgusting. Well, this lady went to a GP registrar for the purposes of a facial spasm that she was experiencing. And he said that it might be a cyst in the ovary and gave her an examination, internal and invasive examination. And it's just disgusting. You think that you can trust the doctors you go to, and it's a scary thought.
And Don, surprise, surprise, he's been deregistered.
Well, he was deregistered a VCAT. He actually took to Supreme Court of Appeal trying to overturn the VCAT decision, which obviously Supreme Court, in the wisdom, said no, they upheld the decision and he's struck off.
And applying all objectivity you can, there's no way you could link the face and the cyst.
So we're not doctors, but I think there is no link between those two. But
we're going to get our sponsors break. Viewers, stay tuned. After the break, we're going to talk about the interaction between work cover and transport accidents. So don't go away. Viewers, welcome back to the show. Today's episode is about the interaction between work cover and transport accidents. Don, as an example, we're talking about the taxi driver who's blown a tyre, gets out on the freeway to change the tyre. Is that a transport accident or is that a work cover accident?
Okay, it will be a work cover accident in the sense that he was injured during the course of his employment. So he would have entitlements to work cover benefits, the statutory entitlements.
But wait, he got hit by a car?
Yes, he got hit by a car, but because it happened during the course of employment, he has to lodge his claim with the work cover insurer or work cover.
All right, Aki, assuming his car broke down, he's inside the car, the engine's on, someone runs into the back of him. Is he entitled to work cover or is it a transport accident case for benefits?
Well, Tony, like Don said, it would still be under work cover for no-fault benefits and for impairment benefits, but it would fall under the TAC system for common law damages.
Don, it's confusing. Why wouldn't it be TAC? Because he got hit by another car.
Well, it excludes... Where there's an agreement between Work Cover and Transport Accident Act or Transport Accident Commission, whereby if you're injured during the course of employment as a result of a transport accident, your claim for those no-fault benefits, Tony, that is your medical expenses, your weekly wages and a lump sum impairment benefit are covered by a work cover scheme.
Okay.
But if you want to access the common law, your common law rights, that goes through the TAC,
All
or
right.
Transport Accident Act.
Just on that, Aki, this person sustained serious injuries. So the next step would be to apply for a serious injury certificate under the Transport Accident Act. Is that correct?
That's correct, Tony.
Okay. If you get the certificate for serious injury, then what do you claim?
Well, you go ahead and sue for damages, basically. So you're suing the person at fault who would be covered under the Transport Accident.
And you're suing for what? Pain and suffering,
Correct. And economic loss.
loss of enjoyment of life, and loss of income.
That's
Now,
correct.
Don, when you sue for that, the money you've already had under work cover, that's got to come off, doesn't it?
That's right. It's what we call the keep factor, where what's being paid has to be repaid back to the insurer. So if you look at the taxi driver, for example, he would receive all these benefits through the work cover insurance component, which includes wages and medical expenses, and also lump sum. When he pursues a common law claim, what has to be repaid to the work cover insurer is the weekly payments, the impairment lump sum, but not the medical expenses, Tony. They remain.
No.
In Victoria, under the work cover system or the transport accident system, you cannot settle up your medical expenses. They remain under the no-fault system.
But Don, if you settle your case out of court, you generally settle on what they call a retention of benefits basis.
A keep basis. We call it keep. So usually it'll be an additional sum on top of that. So it's taken into account. So Tony, it's very complicated. I mean, in the case we're going to do tonight, you can see it's not straightforward because
Okay.
we're talking about select few cases. One, there are accidents that happen during the course of employment. So, for example, if you're a career driver or taxi driver, that's part of your employment. Get involved in a transport accident, that's covered by, again, what we call the crossover. Journey accidents, that is going to and from work from home, they're not covered by your work cover insurer. So if I'm travelling to work from home and I get involved in an accident, I cannot claim on my work cover insurer. I have to make a claim with the Transport Accident Commission.
Okay. But assuming you're at work and your employer sent you to another branch, that is covered by work.
That's covered by your work cover insurer. That's correct.
Okay. Let me give you another example, Aki. A truck driver drives to a yard, parks his truck, starts to unload the cargo, crushes his hand. Is that car accident or work?
That would be a work accident, Tony.
Okay. If you're going to sue anyone for damages, you've got to apply it to WorkSafe.
That's correct.
Okay. But assuming, Don, that the injury was caused in some way by the driving of the truck, or is it use of, or both?
Well, if it's caused by the driving of a motor vehicle, so if it's an incident caused by the driving of a motor vehicle, tram or train, then to access your common law rights, you must go through the Transport Accident
What
Act.
if it's a use of the
use
truck?
of, if it's a use of it, no, you don't. If it's a use of the truck, you just go through your work cover insurer. If
But
it's,
do you need to have the serious injury?
you need to have a serious injury under the work cover insurance.
Okay.
So it's very complicated. It really depends on the
All right.
circumstances. But if it's a use of the vehicle, let's say, it still can bring in somehow the TAC indemnity.
Okay.
So it's a very complicated. So it's not straightforward. It really depends on
All
the
right.
facts.
When does Section 94 kick in, Don?
Section 94 is when you recover your damages. Under the Transport Accident Act, Section 94 is what allows the TAC to pay compensation on behalf of an owner or driver of a vehicle.
You're very keen to tell the viewers about this case of Hughes.
Yes, Hughes.
Far away. Tell us what it's all
Well,
about.
I'll pass over to Aki to give us the facts of Hughes.
Don, the plaintiff in this matter was a truck driver. In 2001, he was driving over a rough section of roadway and he was violently jolted around the cabin. His seat bottomed out during the incident, which means that the underside of the seat actually came into heavy contact with the base of the seat, causing significant impact upon his spine.
So we've got truck driver on rough section of road, bounce up and down, and the seat just breaks, collapse.
Due to what?
The seat being faulty.
All right, wait. Was it a hole in the ground? What did we hit?
No, it was just said a rough section of the roadway and was violently jolted around inside the cabin of
So
the
we're
truck.
saying it was a specific incident. Is that what you're saying?
Well, that was the question. Was that an incident? Was that a specific incident? Or was that just multiple incidents?
How can you determine that when you're bouncing around?
Well, it's exactly right. I mean, it's based on the facts, and that's what the law says. If it's an incident, and it seems like that was all, even though it might have been bouncing around, it's still an incident.
Well,
Now,
I mean, it's a bit of guesswork in that because do you depend on the doctor's done?
well, I think you depend on what he says, Tony. It depends on what the plaintiff says. He said, well, it was all happened all at once. And this
But
is
what
the
if the
fact.
doctors turn around and say, due to multiple bouncing around, your back's gone?
Well, there's still a connection. There's still a temporal either connection between it. That's what the case law says. An incident, if there is some connection to it all, to one incident, which is that even though it was a number of jolts, it was still regarded over the time one incident.
What did the court find, Aki?
Well, the courts held that it was one incident. My interpretation of it is that it was one section of the road and it was during one particular time rather than over a couple of days or over different types of road.
Now, the importance of that, Tony, is that once it's found to be an incident directly caused by the driving, then a person has to go through the Transport Accident Act to access your common law damages.
And if it was more than one incident?
For more than what you go into work code because it wouldn't be regarded as a transport accident.
Viewers, we've got to go to a sponsors break, but I just want to highlight the complexity of the law in this area. Lawyers struggle with the concept of whether it's a transport accident or work accident. So you, the viewer, should and must get legal advice. Stay tuned. After the break, we're going to take up this topic and look at more case law. Viewers, welcome back to the show. Before the break, we're talking about this interesting case of Hughes. Don, you wanted to finish off.
Well, this case just goes to show it is a complex area, Tony. And the lawyers for the plaintiff in this case brought it under the Accident Compensation Act seeking damages. So in other words, seeking a determination that it was serious injury. And in fact, they all agreed that he had a serious injury. The problem in that case was that they brought it under the wrong act. Because it was a transport accident, regarded as a transport accident, they should have made application under the Transport Accident Act.
Who paid for those costs?
Well, I think the plaintiff has to pay for those costs, but they have to go and restart it all over again.
Yeah, but what I'm saying is this. The plaintiff starts the case again, already incurred costs for the defendant. Who pays those?
That's right. Well, usually the costs follow the event, so the losing party pays the other party's cost.
I think the plaintiff's got a good case against his lawyers. Anyway, that's another story. Tell us about the case of Porter and Bonogero Proprietary Limited, Aki. This is something to compare the two cases.
That's right. Tony, the plaintiff in this matter was also a truck driver. The truck that he was required to drive was in a poor state of repair and he was required to drive around Victoria. Now, the truck had a bad seat, it had a faulty seat, as well as the top step to actually enter into the cabin was missing. Now, the truck driver in this matter had sustained injuries to his back due to the long trips and the state of the chair, and he also fell when he was trying to enter the cabin and sustained injuries.
All right, so to get it right, so that the viewers understand, he's injured his back whilst driving, all the bouncing around on a defective seat,
That's
number
correct.
one, and two, he sustained a further injury to his back when he fell getting out of a truck because there was a step missing up the top.
Yes, that's right, Tony.
Okay, so the ladder was defective.
So really there's
Two
two
incidents.
claims in one.
Okay.
There's two claims in
Okay.
one, Tony. And this had to do with, and also there's a lot of complaints that he made about the state of repair of the truck. The truck was very old, it was a 1979.
But that's relevant in terms of the seating arrangements, correct?
The seating arrangement and the steps. He actually made complaints about the seats numerous times and also made complaints about the steps. Now, with the seat, it was repetitive. It wasn't just one incident as compared to the case we just did before of Hughes. This was over the journeys, a number of occasions. It's going onto rough terrain and the seat being in a state of
He
disrepair.
didn't get much for that.
No,
What did he get for that?
I think with that many years ago, it was $5,000. So he won his case, but that wasn't regarded as a transport accident because it wasn't an incident. It was a number of incidences together that caused it.
But he did get a lot of money, Aki, for falling out of a truck because of a missing step, didn't he?
That's right. He received about $820,000 in compensation.
And that's after they took 10% off
That's correct.
because they said if he had been careful, he probably might have.
Now, in this case, they discussed whether or not it's a transport accident, whether or not you need to go through TAC or Transport Accident Act. The court found that it was all work covers a scheme covered by that, so they had to go through the Accident Compensation Act to get the serious injury. Now, just to the point on this case, Tony, is that with the step, which is funny enough, he took a photo of the missing step. The employer disputed that. The employer said, no, there was nothing wrong with the steps. But because he took the photo, it was undisputed. They couldn't deny it.
There was the proof.
There was proof. So it's a perfect example of viewers. If you're in that situation, photos tell many words. That you need those photos. It's the best evidence you can
Exactly,
grab.
forensic evidence.
Don,
Aki, the facts of those two cases aren't that entirely clear.
No.
So, for the viewer's sake, I think it's important that you do get proper legal advice.
Tony, it's a very difficult area to work on. I mean, you've got to really look at the facts and separate it and understand your law.
Viewers, what these two cases highlight is the complexity of these claims and facts. That's why it's important that you see someone specialised in this area of practice so you do get it right. Otherwise, you're going to be out of pocket a significant amount of money, or you could even lose your case.
Because as you can see, Tony, in the case of Hughes, he went through a whole court case when ultimately he was told, you got to start again and go back somewhere else. So,
And incurred a lot of expenses.
Oh, no doubt. It would have incurred a lot of expenses and time. And I mean, the accident happened 9 or 7 years earlier. So it's a long time. And so you've got to get right the first time. And like I said to all my clients, Tony, you only get one chance at this. You've got to do it right the first time.
Okay. Tell us about the case of Orridge and Transport Accident Commission.
Well, Tony, the plaintiff in this matter was a farmhand, a young man who was required to stand on a plant seeder, which was pulled by a tractor in order to plant the seeds of the potatoes. He was required to stand there with a stick just in case the shoots got blocked in order to unblock them. What happened in this matter was that he slipped and his leg got pulled under the plant seeder and he sustained significant injuries to his right leg.
Okay. What happened in that case, Don?
So now the question was whether or not it was a transport accident, because he got injured on this trailer part. It wasn't actually injured on the tractor.
I'd hazard to guess it was a transport accident.
It was a transport accident because the seeder could not operate separately from the tractor. So it was one act. So you had the driving of the tractor which moved or operated the seeder. So it's all one act and it's regarded as a transport accident.
Well, if there was no tractor and this seeder had its own engine, it'd still be a transport accident, wouldn't it?
Only if the seeder is registrable, Tony, and there's a lot of other case law about that. But this is purely because the tractor was a motor vehicle for the purpose of the act, and the seeder, because cannot operate independently of this tractor, is regarded as a transport accident.
You said the seeder has to be registrable. What does that mean, Aki?
It just means, Tony, basically that it needs to be able to be registered under the Victorian laws as a motor vehicle.
And it's got to be
And then it gets
repeatedly
picked up by the Transport Accident Act.
Well, it does, but it has to be repeatedly used on public roads. I mean, there's a lot of different case law, Tony, about that. But in this case, it was a good example because it was whether or not it was a transport accident. The TAC said it wasn't a transport accident, so they had to run a case purely on whether or not it could be accessed under the Transport Accident Act. So it was again, another case law going through all these little details about what is a transport accident and whether or not you go under work cover or the TAC.
Don, what was the final result?
The final result, it was a transport accident, so therefore he had to go through the Transport Accident Act to access his common law rights. Tony, let me quote what Judge Bowman said in this case. He said, "Without wishing to tell government agencies how to run their affairs, it seems to me that it would be more cost efficient and user-friendly if one agency, say the Victorian Work Cover Authority, accepted responsibility for the conduct of the matter. And the question of whether or not responsibility in fact rested with the other agency should be determined later." So purely, what you're saying, Tony, is that get one agency to run it all and then decide if it's a transport accident to work cover at the end of the case.
We've gotten towards the end of the show, guys. Aki, is there anything else you'd like to add before we go?
Well, Tony, obviously it's a complex area of law and you should get legal advice.
Viewers, the only thing I'd add is go to our Facebook page, go to Twitter, give us your comments because obviously you'd have plenty to say about this topic. Go to our past episodes, stay tuned for future episodes and always remember to stay safe.